Landlords across America. There is many reasons today for jubilation, happiness, and joy. And those reasons are: this is the Landlord Advocates, where we help landlords become better landlords. I'm your host, Matthew Lyman. Welcome. That reason is late last night, August 26th, 2021, the United States Supreme Court, in a 6-3 ruling, has decided that the new revised Centers for Disease Control Eviction Moratorium that was set to expire on October 3rd, 2021, is unconstitutional. We knew it was going to happen. We knew it. This channel had mentioned before that when the CDC extended it to the end of July, and it was put forth before the Supreme Court, that Justice Brett Kavanaugh said that it would be up to Congress to extend this moratorium if it were to happen again. Well, the Biden administration and the Centers for Disease Control blatantly disregarded that statement and decided to do it anyway to October 3rd, knowing full well that it did not meet the muster that would pass with the U.S. Supreme Court, that it would be constitutional. Their argument was that by the time the U.S. Supreme Court gets around to hearing the case and deciding on it, it would be over. Wrong. Very, very wrong. And here's why. We believe that Justice Brett Kavanaugh and Chief Justice John Roberts, who supported the continuation to the end of July back in June, did so thinking that it would be over with by the end of July. Justice Brett Kavanaugh said that any further extension of this moratorium would have to be done through an act of Congress. And we believe that Justice Kavanaugh was very spiteful and very angry about what the Biden administration and the CDC did to go over his head, to disregard his comments from the U.S. member and Associate Justice of the U.S. Supreme Court, was not a good idea. And that is why this ruling has been made so quickly that Justice Kavanaugh and Chief Justice Roberts have sided with the other conservative members of the U.S. Supreme Court to shoot this down in a 6-3 ruling. Now, the other side has got comments, and there will be a lot of comments coming out today, tomorrow, and rallies. Who knows what else? Riots and rallies? Will that happen? Who knows? But this is a comment from White House Press Secretary Jen Psaki. As a result of this ruling, families will face the painful impact of evictions. Painful impact? What are you talking about, Psaki? What are you talking about? Painful? Painful is knowing that my hand is going into a bee's nest and I am going to get stung, but I'm not going to stop. I'm going to reach in. I deserve what I am going to get happened to me. I deserve to be stung. Many, many tenants, a supermajority of these tenants, have failed to pay anything in their rent for 8, 10, 18 months, 20, 22 months of rent. They have failed to pay, knowing full well that eventually it was going to come to an end. So, Psaki, when you call this painful, what are you talking about? They knew it was going to happen. Oh well, it was painful, so be it. Painful? Is it painful because when they're loading up the moving truck, they bang their head on the door, they smack their finger in the door? When they close their finger in the door, is that what you mean by painful? We'll give you that. We'll call that painful. But in the other regard of calling it a painful eviction, not for us landlords, it's not. She goes on further to say, and communities across the country will face greater risk of exposure to COVID-19. Psaki, do you ever get out of the White House? Do you ever walk the National Mall? Because when you make comments like that, it's foolish. It's ridiculous. And here's why. When you talk about the exposure of COVID-19 and the spread of COVID-19, the same people that you're referencing are the ones that will be rubbing elbows with you at the National Mall, grocery stores, convenience stores, gas stations, malls, parks, libraries. You get the point, Saki, I hope. These same people are going to be, and they have been for months, going to these locations where lots of people are going. Grocery stores, lots of people, Walmarts, sure, they're there. But now, I guess COVID-19 is an issue. Of course it is. It's always an issue when it's convenient for the person using it to hinder something that might harm them, like an eviction. But when that's not on the table, COVID-19, what's that? But it's only an issue when it affects their livelihood. They're being able to stay in a dwelling without paying rent for months on end. Then it's an issue. I'm afraid to catch COVID. Oh no, please, I can't get evicted, please. Then another member of Congress made comments. And we all know who she is. Cori Bush from the state of Missouri. Cori Bush is a member of Congress who earlier this month, late July, early August, decided to camp out on the steps of the United States Capitol to show in solidarity with all the tenants what will happen if they get evicted and the violence behind those evictions, and they can't happen. We can't let it happen. That's why I was just crying and blubbering about it. All the while laying on one of those big lounge chairs that you would use on the beach, surrounded by snacks to fill her face. All the while crying about, oh, the woe of evictions. She goes on to state, tonight, the Supreme Court failed to protect the 11 million households across our country from violent evictions in the middle of a deadly global pandemic. Ladies and gentlemen, the Emmy in the comedy series goes to Cori Bush as Best Actress. Congratulations, Cori, you deserve it. You talk about violent eviction? Evictions are not violent, Bush. They're not violent. If they are, it is because the tenants have created that situation. Marshals, constables, and sheriffs are not violent when they're doing eviction. If violence is procreated from that situation called an eviction, it's because of the tenants. And the tenants barricade themselves in the apartment, and law enforcement has to use a battering ram to take down the door. Oh well, that's because of the tenants. If the tenants put up a fight or are violent when the sheriff or marshal or constable is there to put them out, well, then they get arrested and put in the back of a patrol car. Okay? Again, they caused the situation that put him in that position. Not the law enforcement and not the eviction. So we ask you, Cori Bush, how is an eviction violent? We know that you won't respond to this because you don't have an answer. And if your answer is, you know that my landlord advocacy will tear up that answer so fast that it will humiliate and embarrass you. So we know you won't answer. You or your colleagues, the squad, the seal weavers of the world, none of you address that. You want to wave the white flag of, oh, woe is me, please stop, please, I surrender, don't hurt me anymore. Stop. Evictions are not hurting anyone. You're helping landlords recover the properties that tenants have not been paying on for months and months on end. She goes on further to say, we already know who is going to bear the brunt of this disastrous decision. Black and brown communities, and especially black women. That is very divisive. To claim that it's going to be impacting the brunt will be black and brown communities, especially black women, that's racist, Ms. Bush, that's racist. So because of your assertion, eviction should not happen at all. Nobody should be evicted whatsoever because the brunt of it, in your mind, is black and brown communities and especially black women. So if this was the majority of those getting evicted were white people, would this be an issue with you? I don't know. But we will tell you, it doesn't matter what race, creed, disability, age of the person being evicted. We are not here to be divisive like you are, Cori Bush. We are here to say that landlords have had enough. Landlords should not be thrust into a position of contemplating suicide themselves, looking at losing their lifetime investments, while tenants are celebrating the fact that they cannot be evicted and they don't have to worry about paying their rent. Why should landlords bear the brunt of that? They have been bearing the brunt of that now for at least 18 months. You don't mention that at all, though, do you, Cori Bush? Of course not. And for those advocates out there that are talking about getting the money to the landlords, this emergency rental assistance program, quite frankly, we believe that your interest is not for the landlords, it's for the tenants. You could care less if the landlords get paid. All you care about is that the tenants do not get evicted from the places that they're not being paid for. That's all you care about. We know this, landlords, and we will show later on at the end of this video, you will be able to watch the ERAP video that we did about the smoke and mirrors and how that is. But one of the things that we want to add to this is that with the ERAP program, if your tenant applies, the eviction at any stage in the court system in the sheriff's office is now going to be stayed until a determination has been made whether or not the tenant qualifies for ERAP funding. Now, we have it on good authority right from the mouths of tenant advocacy groups that they plan on being in courthouses and all places like that where tenants may go and congregate to get help or get evicted. They are going to be there with ERAP applications, handing them out like you hand out candy to children on Halloween. Why? Because they know that when a tenant applies, it holds back the eviction. For how long? 2, 3, 4, 5 months? Who knows? But they know that this is going to happen. And they're going to be handing out these applications to people that they know full well will never qualify. But it will just stop the evictions as long as they possibly can. That is immoral, it is unethical, it is unprofessional for advocacy groups for tenants and the legal aid societies of the world. If they're doing it, that is unprofessional and is unbecoming of a professional to do something like this. When you know that the tenant will not qualify. And they do qualify, sure. But the issue that we see happening is that the tenants are going to claim that they applied, even though the application process opened up on June 1st, 2021, that they are going to claim that they applied, and that claim will be that they applied 1 week before they had to go to court. Knowing that the clock is tolling from the moment that they apply 2 or 3 months out. But if they applied on June 1st, and they're in court in August or September, then it would coincide that they were approved or denied, and therefore approved, they get their rent paid. But if they're denied, they're going to get evicted. So they don't really care if the landlord gets the rent money. They care more about being able to stay in the apartment whether or not they're paying the rent. So they have no concern about applying for the ERAP program any earlier than what they need to. Hopefully that is not going to be the new national eviction moratorium. And hopefully that the money that is out there gets put out there as fast as possible. So as awkward as this sounds, that there is no more money available, because when there's no more money available, the ERAP program dissolves, goes away. And at that point, there should be no more moratoriums anywhere across the United States. Now, landlords, stay tuned for future videos. We have some other information out there that will enlighten you as to things that are on the horizon, especially in the state of New York, against landlords. But in the meantime, we ask that you subscribe to our channel, hit the like button, hit the notification bell so that you're made aware of other videos that we are going to be producing, and also leave comments because we do respond to the comments. We appreciate you. You know that we are here with you. You know that we are here for you. And until our next video, stay safe and be well. Take care.